Hi guys, my name is Aakarsh, as I'm sure you're all aware from the publicity that's been done. In today's session, I'll try to give you a glimpse of how I went
Akash,
about my preparation.
Akash. Let me say something first, and then I'll hand over to you.
Sorry, my bad. Yeah,
Yeah, cool. Good evening, everyone. This is Anish Gupta, and I am here on behalf of the National Law Training Institute. We have today among us Aakarsh Bafna, who got a rank of 6 in CLAT 2022. Aakarsh is one of the smartest people that I know in our junior batch, and he's often seen teaching law to law professors, and he'll be able to solve every question that you throw at him. So, yeah, with this, I hand over this session to Aakarsh, and yeah, please take over.
right. Thank you for that very flattering description, but I'm sure that's not the case. So, yeah, throughout our sessions, I'll try to give you a glimpse of how I went about my general CLAT prep and, in particular, the legal reasoning section. But I'll also be focusing a lot on general strategy because it connects a lot. Legal reasoning is the most important part of your entire CLAT paper. And in that regard, I think general strategy will play a huge part. Right. So let's skip straight ahead into how legal reasoning is different from every other section. Now, in the entire CLAT paper, there's 5 sections, right? You're all aware of it. There's English, there's CR, there's logic, there's English, there's CR, there's legal, there's quant. All of it's there. Legal is the only section that is completely relevant to your career. That is the only thing that tests your aptitude. And that's why it's different. In a critical reasoning passage where you go through the passage and think about the best possible outcome, you never do that. You never do that for legal reasoning because you're given a set of rules to argue under. You're given a set of rules to find the best possible answer from within those rules. You don't think of anything that might be the best in that case. You don't think outside a box. You put yourself in a box in those rules, and then you think from there on. That's how it's different. Now, before that, I'll just give you a brief intro of when I started my prep. So I started my prep back in class 11, 2 years back. I prepped for CLAT the entire time with school. So I get how it might be stressful for you, especially given there's approximately 4, 5 months left for CLAT. But one thing I would recommend is balance. Don't focus too much on your schooling right now. It's time to focus on CLAT. Now, the legal reasoning section in CLAT in particular, as I'm sure you're all aware, 35 to 39 questions. That's the thing on the website. Passages will not be long. They'll be about 450 words each. In many mocks, you will come across passages that are 1 page, 2 pages. Those passages are just there to throw you off, to make it a little more difficult for you to complete the paper on time. But don't worry about it. Actual CLAT will not be that difficult. Now, the reason why the legal reasoning section out of all the other sections is more important is because it's not only 25% of the entire paper, it's the tiebreaker section. Now, for example, if you get 95 in CLAT and somebody else also gets 95, the only way they can distinguish between you two, the one who gets a higher rank, as to decide that, is on the basis of your score in this section. If you got 37 in the legal section and the other person got 35, you'll get the higher rank. But of course, if you both got 37 or any other same score, the rank goes to the one who's older chronologically. So that's there. Right. You reason within the rules. And in the legal section, what I did was whenever I started my paper, I even in my mocks, I prefer to have a handout, a printed one, so that I could flip through the pages, get a feel of the entire thing. In the first 3 to 4 minutes, I flipped through the entire paper. I didn't read any questions. I just got a general outlay of the entire thing, like what topics are going to be in English, what kind of passages there are in legal, what kind of questions they're asking. You just glance through it. You don't sit to read through the options. You don't sit and read the passages. You just take one word, 2 words, one glimpse of whatever there is, so that you understand what the passage is about and you know exactly what to expect when you get there. One question that people ask a lot is, what do I do when I get something that I don't know of beforehand? You don't do anything. You're not supposed to know anything beforehand. That's the CLAT syllabus. You're not supposed to have any legal knowledge. Of course, that's the syllabus on paper. It will help to have legal knowledge, and that's why everybody who prepares you for CLAT will tell you to read contract law, read tort law, the basics of it. But if there's anything outside what you've read, for example, in our case, in many mocks we had abortion, we had mediation, all of those topics, you might not have read about them, but that doesn't mean that you can't answer them properly, because you don't need to know anything about them. Like I said, you reason with a given set of rules. You don't think like, what can I do that would be best? You don't try to come up with a new solution. You try to find the optimal solution from whatever you have been given, right? That's how it's different from finding the best possible way to climb a wall, right? There you would think, okay, maybe I can throw a rope, maybe I can use any other mechanism. Here you don't. You have been given the tools, and you have to use those tools the best way you can. Now, let's go into approaching the passages, but before that, a general disclaimer. Whenever I'm going about explaining something, if you have any questions, please do type it in the chat box. It's extremely important to keep these as engaging as possible. Right. Now, the weightage in CLAT, while the others test your general skills, you can go about the other passages any way you want. But here, there are specific sets of methods that people generally rely on. Method one that I've seen used many times, you get the paper and you straight away start with the passages. You read and you solve the entire thing in one go. You start with the passage, go on to the questions, and that's done. Right. But there's another method, and this is flipping through the section. You take a look at the passages, you take a look at the questions, what kind of stuff you think they'll be asking. You get a general lay of the land, and then you begin solving. This might take a little more time. This might cut away time from your actual solving portion, but this, in my opinion, is worth it. Right. So what would you guys choose? Please type your answers in the chat box. Guys, I'd really recommend you answer method two. All right. Anyone else? Right. See, I see an overwhelming response of second one, but Amantagi, for me, the best is the first one. See, this is exactly it. Whenever you're preparing for any competitive examination, there is no right answer to any method. Okay. Method two might objectively look the best because you get a lay of the land, you glance at the questions, and that's it. Personally, I use method two. But one thing you will understand in your months of CLAT prep is there is no right answer. Do whatever suits you best. I have friends who I prepared for CLAT with. Many of them, they used to just sit with the paper, start solving. They never went through the paper. They opened the booklet, read the passage, solved in the exact order the questions came. That doesn't matter. Whatever suits you is best. Don't let anybody tell you otherwise. There could be a million YouTube videos telling you time your sections, do this, do that. Don't. Do what suits you best. Of course, you can try out a few different things, but always do whatever you think is best. No one can tell you otherwise. Uh, right. For those of you who haven't tried the second one, I would recommend trying it. Does accuracy differ in both methods? No, again, it's a very subjective thing. So I've tried both methods. Initially, in my starting few mocks, like 5, 10 mocks, I always used to just start with the paper and start following. Okay. But that wasn't really helpful for me because I didn't know what to expect. Personally, if I know what to expect, I'm all the better prepared for it. Granted, the test has already started, but once you understand what's happening further, you have a better understanding of it. Again, that's a very personal thing. If method one suits you better, stick to method one. If method two, you think method two might help you, give it a shot. You won't get tangible results in one attempt. In one mock, you apply this method and you will get a 10 mark score increase. That won't happen, right? You can try it for 2 mocks, 3 mocks. If it works for you, well and good. If it doesn't, stick to what works. Right. So with this, I think we can go on to solving one passage just to identify how you skim through it and how to eliminate the irrelevant details. Give me a minute, guys. Guys, I see a lot of questions here. I'll be answering the questions towards the latter half. So, is it all right if we just get to the thing first, solving the passage? Let's see how we approach it. Give me a second while I share my screen, guys. Okay, there seems to be some problem with Chrome. Ah, all right. I might have to
Do you want
quit it
me
for a
to do
minute.
something, Akash?
Can you share the CLAT 2022 paper?
I'll try. Yeah. Can you send it to me on WhatsApp? Oh no, I have it. Wait.
Okay, cool. Right. In the meantime, I'll take some questions. Swaragin, you got this. Thank you. I needed the motivation. What was my sequence for attempting mocks? Okay,
Can you see
so
my screen? No, wait.
yeah. I can see it now.
You can say it night.
Yeah, I can. Scroll down to the legal section, please.
Yeah. Which
So I'll
passage?
be solving two passages that I heard from people were the most difficult for the most people. So I'll get to those first. I think it's question number 91, the passage on monism and dualism.
Right. Yeah.
Right. Could you zoom in a bit?
Better.
Yeah, perfect. So now the first way I'll teach you how to approach it, right? Read it because there's a lot of content here. There's 450 words. I can guarantee you not even 150 words are relevant for your principle. Okay. You read a passage, you remove all the irrelevant details, you underline, that's what I used to do. Underline whatever principle there is. You identify a principle, right? Only on those principles will you answer the questions. The rest of the sentences are not relevant for you. Okay, so let's start with this. There are two principal theories on the relationship between international law and domestic law, monism and dualism. This is an introduction, fine. The monistic theory maintains that the subjects of two systems of law, international law and municipal law, are essentially one. Okay, this is important because it tells you monistic theory means they're the same. Okay, as you're reading sentences, many of the sentences will be elaborate and complex. Condense it in your own mind. All right, bring it down to very simple words. Here, what I'm going to do is international law, municipal law, the same thing. This is what the sentence means. The monistic theory asserts that international law and municipal law are fundamentally the same in nature and arise from the same science of law and are manifestations of a single conception of law. You see many heavy words here, manifestation, conception, it does not matter. It is doing exactly what the previous sentence did. It's saying that they are the same in nature and they arise from the same thing, the same science, whatever it is. Doesn't matter. The followers of this theory view international law and municipal law as part of a universal body of legal rules binding all human beings, collective or singly. All right, let's read on. In a monist system, international law does not need to be incorporated into domestic law because international law immediately becomes incorporated in the domestic legal system upon ratification of an international treaty. All right. So, what the followers of of this theory, they view it as an entire big circle. All right. All of this entire circle is the world, and the international law is a larger circle, and the domestic law is a smaller circle. It's a part of the same system. So the moment something becomes a part of international law, you don't need to insert it into domestic law. It's automatically a part of domestic law as well. And because international law here is the bigger circle, as this passage goes on to explain, domestic law is subordinate to international law, according to this theory. This is what the next sentence does. Then they go on to an example. The statute of the International Criminal Court, therefore, can be directly applied and adjudicated in national courts according to the monistic theory. So, if there's any disputes regarding international law in a monist state, you can go to the domestic courts. That's fine. It's automatically incorporated. There's no need for anything more. All right. Now we move on to the dualist theory. Here, they represent two distinct systems. It's not a big circle and a small circle. It's two different circles now. According to dualism theory, international law and municipal law represent two entirely distinct legal systems. In essence, international has an intrinsically different character from that of municipal law. International law is not directly applicable in the domestic system under dualism. Okay, so it's not like it was in the monist state, that the moment something becomes a part of international law, it's automatically a part of domestic law. Here, you need something a little extra. That's a relevant thing here. You should underline this one. Then, first, international law must be translated into state legislation before the domestic courts can apply it. Okay, so this is a bit of legal terminology here, translated into state legislation, all of it. Doesn't matter. What they're trying to say is, before international law can be applied in a country, you need to have a country's law for that, a specific law from the government of that country to make international law binding. Courts otherwise cannot apply it. For example, under dualism, ratification of the statute of the International Criminal Court, you don't need to know what the International Criminal Court is, but just for context, there's two international courts, the International Court of Justice and the International Criminal Court. All right. The International Criminal Court obviously deals with criminal matters. But I've seen many questions asked on what if I don't know this? When you're reading a passage, if you don't know something, do not be worried. Sometimes people just get a little nervous because they don't know a concept. You're not expected to know a concept. Always remember that. If you know it, that's an added benefit. Sometimes it's a problem too, but do not worry. Ratification of the statute of the International Criminal Court is not enough. It must be implemented through state legislation into the domestic system. Most states and courts presumptively view national and international legal systems as discrete entities and routinely discuss in dualist fashion incorporation of rules from one system to another. Heavy words, long sentences. What they're saying is, in the dualist theory, international law, municipal law are separate. Most states are dualist, and if you want international law to apply in a country, you have to have a state law for that. That is all. That's the entire thing this passage says. Now, let's move on to the questions. Anish, if you could scroll down. The first question. In light of the given passage, which of the following statements is correct? Monism and dualism are similar approaches to adopt international law. It's pretty clear this is not a similar approach, right? Because big circle, small circle, and two different circles. Very simple. No. Dualism postulates the homogeneousness of domestic law and international law. Homogeneousness is being the same, right? It's obviously not the same because dualism treats international law and domestic law differently, right? They treat it as two different entities, but monism, that the theory of monism, it treats it as a universal thing under the same universe. So obviously this is not an answer. Monism and dualism are different approaches to understand how domestic law impacts international law. Not really. They aren't. Right? It's about the nature between them. Now, option D. So A, B, and C stand eliminated. C could be a little iffy. You might be tempted to go for C, but let's not. Read option D. Monism postulates the homogeneousness of international law and domestic law. Now, this is the only thing that makes 100% sense, right? Because it did say international law and domestic law, it's a single universe. You don't need any distinct entities. They're not distinct entities. That's what it says. That's why D makes the most sense. And that's why I'd go with D, elimination. Now, guys, keep in mind, when I'm reading this out to you, I'm reasoning through all of it, right? But when you're solving mocks, you won't reason this much. You won't explain. You'll read fast and you'll skim through it. But right now, I'll take it a little slower. Right, the next question. X is a developing country. X ratified the United Nations Framework Convention on Climate Change in 1995 and incorporated the provisions of the said convention in its domestic legislation addressing climate change in 1996. Doesn't matter. The years don't matter here. However, X has been widely criticized in the international community for for its failure in meeting the obligations under said convention. There's another country, Y. It's a developed country. It ratified the same convention in 1995, but has not incorporated its provisions into the said convention. Y has been appreciated by the international community for its success in meeting the obligations, but now they ask what is correct. You have to identify, look at the options. That's how you'll understand what the question is. They're asking which is a monist state, which is a dualist state, right? X is a monist state. Okay, that does make sense because, well, look at it. X has been widely criticized for not meeting it. It incorporated the provisions into its legislation. You think it's a monist state then? It's not, right? Because if it's translated international law into domestic law through a state legislation, it's not a monist state. It's a dualist state. Y did not translate it into domestic legislation. There was just the international thing and they met the obligations. So X seems dualist and Y seems monist on the face of it. Now let's see the options. A says X is a monist state, Y is a dualist state. No, the opposite. B says X is a dualist state and Y is a monist state. This is the correct answer. But still, I wouldn't recommend just reading two options and just letting it be. Read the remaining options. C says X and Y both monist states, not the case, eliminate this. D, both dualist states, not the case, eliminate this. So here the clear-cut answer is B. You go with B. Any questions on how I'm approaching these two kind of questions? If yes, put it in the chat box. I'll come to it at the end of this passage. Now the next question. D, a dualist state, has signed and ratified the agreement on trade-related aspects of international property rights. Wow. An international agreement administered by the WTO. If D is compelled to fulfill its international obligations under the TRIPS agreement, which of the following is correct? Now, for this, keep in mind it's a dualist state, right? Because it's dualist, it needs to translate international agreements into state legislation. So D, option A, D may adopt the provisions of TRIPS without enacting a domestic legislation. Okay, that's wrong because it's a dualist state. That's clearly not the answer. B, D may not incorporate the provisions of TRIPS into a new domestic legislation. May not incorporate, this doesn't make sense much. C, D must incorporate the provisions of the TRIPS agreement into an existing domestic legislation or a new domestic legislation. This is the one that makes the most sense out of all the options. By far, this is the best yet. But let's go to D. D may not incorporate the provisions of the TRIPS agreement into an existing domestic legislation. It doesn't make sense, right? So very clearly here, the answer is C. Anish, the next question, please. Okay, which of the following statements is incorrect? In these kind of questions, you're going to have to read it word for word, right? The options, many times they'll just change one word in two options and trick you with that. You'll be tempted to fall for it, but that's why I'm recommending read it word for word. Let's go to the options. According to monism, the nature of domestic law and international law is the same. True. And domestic law is subordinate to international law. Okay, this is correct. So this is not the correct answer here because they're asking the incorrect one. B, according to monism, ratified international conventions automatically become a part of domestic law and domestic law is subordinate to international law. Again, it's true, so not the answer. C, according to dualism, ratified international conventions automatically become a part of domestic law and domestic law is subordinate to international law. This is very clearly wrong because it's only according to monism that domestic law is subordinate to international law and international conventions become a part of it, right? So this is wrong, but still we'll go to option D. According to dualism, the nature of domestic law and international law is different and domestic law is not subordinate. This is correct. So this is not the correct answer. Here, C is the only statement that is incorrect. Therefore, we go with option C. Now, 95. Country X has ratified an international convention which requires each state party to enact laws defining and punishing bribery. Okay, fine. Then they've defined bribery. The convention has neither defined bribery nor prescribed a punishment for the same, so that each state party may define the offense of bribery differently in their respective domestic legislations. By 2022, X has not enacted any law defining and punishing the offense of bribery. In November 2021, Mr. A was being prosecuted by a domestic criminal court in X for allegedly bribing to a government official, allegedly offering a bribe to a government official. I'm sorry. In the given situation, which is correct? If X is a monist state, Mr. A can be punished for this. Let's go on. If X is a dualist state, Mr. A can be punished for committing an offense under the convention. All right. If X is a dualist state, Mr. A cannot be punished for committing an offense under the convention. And D, Mr. A cannot be punished for committing an offense under the convention, irrespective of whether or not X is a monist or a dualist state. D is the most clear and opportune answer, because the facts of this question very clearly say the convention has neither defined bribery nor prescribed a punishment for the same. So if a law hasn't prescribed a punishment for something, how can you be punished under it? It doesn't matter if you're a monist state or a dualist state, right? This is the signature trick question that many mocks will give you, that even CLAT gives you, like this one did. Because here you will be tempted to go with X is a monist state because X has ratified it. There's no domestic law. Right? There's two important facts here. X has ratified the international convention, and there's no domestic law in X country for this. So automatically you might think the international law binds, right? But it does not, because the convention itself hasn't defined bribery or prescribed a punishment for it. Right. So guys, what questions do you have from this? I will be solving another passage with you. So yeah, Aman, question 92 is not clear. What's not clear about 92? Anish, could you please scroll up to 92? Yeah. Guys, whatever questions you have, whatever doubts you might have from whatever I'm saying, if I'm not being clear enough, let me know. Type it out in the chat box. Okay, all right. I'll just go through 92 once again. It's a paragraph, right? Condense it. Like I said about the passage, read the sentences, take out the main point. X, developing country, X ratified this convention, climate change convention in 1995. All right. X incorporated provisions into domestic legislation. Okay. X has been widely criticized because it failed to meet the obligations, even though it did all that. Okay, that doesn't matter much. Y, developed country. Y ratified the convention but did not put it in state law. Y has been appreciated in international community. This is the entire passage. All right. It doesn't matter if they're not appreciated or they are appreciated, but X ratified it, made it state law, but didn't meet up. Okay, there's three relevant points. Y ratified, did not incorporate it, did meet up. So despite not incorporating it, met up, that means it's thinking it's binding. That makes it monist. X, despite incorporating it into state law itself, which by definition means dualist, it did not bind it. It did not carry it out. That's how the difference comes. Aman, how can it be a dualist state? How can what be a dualist state? X or Y? Okay, obviously, objectively, X is the only dualist state here, but it's a dualist state here because they signed the international convention first, and after that, they put that convention into domestic law. You read this part of the sentence, and incorporated the provisions of the said convention in its domestic legislation addressing climate change in 1996. So it translated that, going back to the wording of the passage, it translated it into domestic legislation, right? So that's why it's a dualist state. All right, great. With that, I think we can go on to the next passage. There's another one that most people are confused on about the mistake of fact and mistake of law. Anish, if you could go to the passage on question 101 to 105. Right. So let's have this one now. When parties to a contract are under a mistake regarding an important fact related to such a contract, it may affect it in two ways. This sentence means if there's a mistake of fact, if there's a mistake about a fact, they can have two effects. It can have two effects. It may firstly defeat the consent altogether that the parties are supposed to have given, that is to say, the consent is unreal. Okay. Two or more persons are said to consent when they agree upon the same thing in the same sense. Now, this is a very important line because this is a principle in and of itself. Okay. You don't need to, in this passage, you're not having to understand one sentence to pull out the principle. They have given you the principle right there between the lines. This is a very important part. Underline it. Two or more persons are said to consent when they agree upon the same thing in the same sense. That's fine. Perfect. The sentence before this, okay, that means that one effect that a mistake of fact might have is it may defeat the consent. The consent that was required for a contract, it's no longer there. That wasn't there in the first place. That would be making it say. Secondly, the mistake may mislead the parties as to the purpose which they had contemplated. Okay, so when you enter into a contract, you do it for a certain reason, right? This mistake of fact, it might mislead them. That's what they're saying. Where the mistake does not defeat consent but only misleads the parties, that is, where both parties to an agreement are under a mistake as to a matter of fact essential to the agreement is void. All right. So they're saying that when it's not the first case that is described in the second line that it defeats the consent, but what it does is mislead the parties about the subject matter, and the subject matter, the particular fact that they're talking about, the mistake where it was made, if that fact was extremely important to the agreement, then the agreement is void. That's what they're saying. However, if the mistake is concerning an erroneous opinion regarding value of the subject matter of agreement, it is not a mistake as to a matter of fact. Okay, it's an opinion, it's not a fact. That's why it can't be a mistake of fact. It's a mistake of opinion there. Although it's not a technical term, but like it's there. Thus, the agreement is void when one, both parties to an agreement are mistaken. Both need to be mistaken. That's what they're saying. Two, the mistake is about a matter of fact. And three, the fact about which they are mistaken is essential to the agreement. Further, it is pertinent to note that a mistake, in order to invalidate a contract, should be a mistake of fact and not a mistake of law. Furthermore, where only one party to the contract is under a mistake of fact and the other party is not, the contract is not voidable merely for such reason. I'll condense this entire paragraph into a few lines for you. Mistake of fact, a mistake about any fact, can do two things. It can defeat the consent of parties, or it can mislead the parties about what the contract is about. All right. A mistake of fact, when it's not defeating consent, and in this case, when it is misleading the parties about the purpose of the contract, it will mean that the contract is void only when both parties are under a mistake of fact. The mistakes that they've made, the fact that they're concerned with, is extremely important to the agreement, and the mistake, like I said, is a matter of fact. They've given three conditions. Both parties must be under the mistake. Mistake is a mistake of fact, and the fact is essential to the agreement. This is what the entire passage is talking about. Now, this part about them saying it should be a mistake of fact and not a mistake of law. This means there's actually a legal principle behind this. Ignorance of the law cannot be excused. Ignorance of fact can be excused. I won't give you the some passages might give you the Latin term for it, but it just means this: ignorance of the law cannot be forgiven. Ignorance of fact can. That's why if there's a mistake of law, the agreement is not void. Then here, mistake of fact there is, but only one party to a contract is under a mistake. Like if I have entered into a contract with my friend, it's to sell a car. He knows what car it is. I think it's something else. It's my mistake. It's not a mistake that we both made. Then it's not void. Then void means the contract does not stand anymore. All right. If you enter into a contract to sell a car, you have a car, you want to sell it, and somebody else is paying you, let's say, 1 lakh for it. Then, if any circumstances arise for whatever reason, if the contract is void, that means you are no longer obligated to sell it to them and get the money. It's no longer enforceable. You can't go to a court and say, well, Your Honor, you have to enforce this contract because it's void now. You can't do anything about it. All right, moving on to the questions. Anish, could you please scroll? Yeah. Mr. A entered into an agreement to sell his bicycle, which had been kept unused in his attic for a year, to Mr. B at an agreed price. However, neither party was aware that at the time of entering into the agreement, the bicycle had already been destroyed by a fire in the attic. Even in the given situation, what is true? So let's understand what this question says. They entered into a contract to sell bicycle, but bicycle does not exist anymore. It is burned, right? But neither of the parties knew. The three tests that were identified above, the principle that we saw, both parties need to have the mistake of fact. The mistake of fact must be important to the agreement, and it's a mistake of fact, obviously. So let's read the options now. A, the agreement is void as both parties were under a mistake as to a matter of fact essential to the agreement. This makes sense. This is true. But we'll read the other options as well. The agreement is void as both parties were under a mistake as to a law in force in India. No, not the case. Eliminate this. The agreement is not voidable as only one of the parties were under a mistake of fact. No, the question is clearly say both of them didn't know it. So it's a mistake of fact for both parties. Eliminate this. Now, D, the agreement is not voidable as the promise made under the agreement had not been performed. This is not relevant to the passage. The passage does not talk about promises not being performed, right? Eliminate this. A is the only thing that makes sense. Go with A. Could we scroll to the next question? Miss X and Miss Y enter into a contract of sale of an article while reeling under the erroneous belief that the sale of the article, which was the subject matter of the agreement, was permitted by the law in force in India. So what is true here? Understand the question. All right. They entered into a contract to sell a particular thing, but they didn't know that selling that thing was illegal. This is a mistake of law, not a mistake of fact. Therefore, we look at the options. A says the contract is valid. No, it's not valid. B, the contract is voidable at the option of Miss X. Now, nowhere in the passage have you seen voidable at the option of someone. So automatically B and C are out of the picture. D, the contract is not voidable. This makes sense because mistake of law, while the passage says just mention mistake of law, it does not tell us what to do in case there is a mistake of law. Hence, this is the most appropriate option, also by elimination, because A, B, and C do not make sense at all. So we eliminate them, go with D. 103. Mr. J entered into an agreement with Mr. K for the sale of Mr. J's club. At the same time of entering this agreement, while Mr. J believed he was agreeing to sell his golf club, Mr. K believed he was buying a clubhouse. Alright. The agreement is void because A, mistake of fact defeated the consent of parties. Fair. This makes sense, right? Because he consented to buy a golf club, he's consented to sell a clubhouse, whatever the case might be, it might be the opposite, but they're not talking about the same thing. So consent is not applicable there. B, mistake of fact misled the parties as to the purpose of the contract very clearly because one thought it's about a club, golf club, the other thought it's about a huge piece of real estate. It's not. C, mistake of fact was regarding the identity of parties. Now, nowhere in the passage has the identity of parties been referred to, and it's not important here. Eliminate this. D says both A and B. This is a very strong option because A and B both made sense to us. And in this case, I would go with D. Right. Number 104. Mr. D appointed Mr. K to manage the cultivation of his land as he was unable to manage it himself due to his advanced age. Mr. K agreed to manage the cultivation of Mr. D's land if he granted Mr. K a lease of the said land. Mr. D agreed to the same and signed a deed which was, unknown to both parties, a gift deed and not a lease deed. In this case, what is true? Now, before we go into the options, I'll give you a brief intro of what lease and gift deed means. Gift deed, by the very term gift, means you're gifting it to someone, okay? You're transferring ownership completely. It's not temporary, it's permanent. You've given it to them. It's your birthday, I'm giving you a gift deed, take it. Khatam. But lease is a different thing. There's nothing technical needed here. All you need to know is lease means I own the property. If you want to take it from me on lease, there's a piece of land, okay? You sign the lease agreement. I give it to you for, say, 20 years. You don't own it. You have control over it. You have certain rights over the land. You possess it. You can live there. You can do whatever you want there. It's dependent on the agreement, but you don't own it. At the end of 20 years, when your lease expires, I take it back from you. That's what a lease deed means. But don't be afraid. It does not matter. You don't necessarily need to know the meaning of lease or gift deed. Just know that they're two different things. And if you know the two different things, you can automatically solve the passage. Now, option A. Mr. D and Mr. K were reeling under a mistake as to a matter of fact essential to the agreement. It's true, they were. But we'll go on to the other options. B. Mr. D and Mr. K were reeling under a mistake as to a matter of law essential to the agreement. Okay, this might be a tricky option for many people because they think gift deed, lease deed, two very legal documents. So if there's a confusion regarding that, is that a mistake of law? No, it's not. It's a mistake of fact. All right, because the fact is He was signing this, but he thought it was that. So that's a mistake of fact, not a mistake of law. C. Mr. D was reeling under a mistake as to a matter of fact essential to the agreement. Yeah, he was, but he was not the only one reeling under that mistake, was he? Mr. D was reeling under a mistake as to a matter of law essential to the agreement. Not really, right? So A, the only option that made sense to us, we'll go with it. Eliminate the rest of the options. This is the kind of question that people generally tend to spend more time over. They get confused. They think, okay, what if? And the moment you start to do that, stop yourself because you're not supposed to do that. What I've understood through whatever questions I've solved for CLAT, through I've given many mocks, every single mock, you understand after a certain point that these mocks don't require you to think so much. Even CLAT, it won't require you to think that much in depth. If you think you're spending more than 30 seconds, 40 seconds on one question, time yourself. See that you don't need to spend more than that on it. If you do, it's not worth it. Trust me. 105. Miss X and Miss Y entered into a contract of sale of an article which was agreed to be shipped by Miss X in a ship called this and delivered to Miss Y on agreed date. Mr. X shipped the said article by a different ship without informing Miss Y, and it was delivered to Miss Y on the agreed date. So in this case, what is true? A. The agreement is void as both parties were under a mistake of fact. Not really. They weren't. B. The agreement is void as both parties were under a mistake of law. No, there is no mistake of law here. Nothing about there being a mistake of law is mentioned remotely in the facts of this case. So we'll eliminate this straight away. C. The agreement is valid as both parties were under a mistake as to a matter of fact, not essential to the agreement. This makes a lot of sense because how you deliver it does not matter. The fact that it gets there matters, right? Miss X said he'll deliver it, she'll deliver it, whatever, and Miss Y got it. It doesn't matter how she got it, right? She got it. This option makes sense. Option D, this agreement is valid as both parties were under a mistake of fact essential to the agreement. The fact was not essential to the agreement, so we won't go with this. Very clearly, the option is C. Right. These are the two passages. So what questions do you guys have about how I solved this, any particular question? Harshada, you asked me what you should focus more on, the questions or theory. All right. So one very, very important thing you need to keep in mind when you're reading legal passage for a test is you are not reading to learn. You are reading to keep it in your brain for less than 5 minutes. Less than 5 minutes. Keep that in mind for a particular passage. You read it to keep it in your mind for less than 5 minutes. You apply it, answer the questions, and forget it. You don't try to absorb it. Don't try to learn it. Because the moment you try to do that, you will be involved in the passage. And the moment you're involved in the passage, your efficiency for the other passages will go down. Because you'll already be thinking about it in the back of your mind. Don't let that happen. It will come with practice, but it will come. So just train your mind that way. Read it and let go. Read it, answer the questions, let go. That's all. Okay, if there is a passage on a topic we already know, like vicarious liability, skip the passage and directly answer the questions. Okay, while we are tempted to do this in most cases, I would recommend against this. If it's completely on a general topic like vicarious liability, don't need to read the entire passage word for word. Right? Like I do for all passages, skim through it. But make sure that you read the sentences, like just when you're skimming through, make sure you know what's going on. Because many times they give you the general concept and then they give you one weird exception to the rule that you wouldn't normally know, but that particular passage has it. And if some question talks about it, you'd have to go back and waste time. So even if it's a very common topic, when you're skimming through it, make sure you identify if there's something else you don't know. That's all. Okay, which sources you refer to as practice for legal reasoning? Okay, so earlier, I obviously had my CLAT mentorship or coaching. I had it earlier. It's called the Opus Way. It's based out of Calcutta. That's where I went. They had the material. They had the classes. I used to rely solely on the materials. But after I started mocks, I didn't give that many sectional tests. I focused on just mocks. So I would recommend taking as many mocks as you can, but don't overdo it. Right? Do however many you're comfortable with. All right. I've just started with the LR section, how to do it from scratch. All right, you will find many books on legal reasoning on the internet. We'll send some in the Telegram. We'll send some names in the Telegram channel because I haven't referred to any external material that way. I used to rely only on my coaching center's material, and you don't need to think much about theory. Just know the basics, and that's more than enough. What sources? Like that's okay. It's the same question. Sources. Okay, you all are very interested in sources. Guys, it's good to be interested in sources, but don't pay too much attention. Right now, there's like 4 or 5 months left for CLAT, right? I would not recommend that you sit entirely and go through theory. The time for that is not now. You can take a couple of weeks and just read the basics, but I would recommend start with mocks right now. It's never too late. Start with mocks. All right, not avoidable. Okay, Ansh. Currently scoring is much, attempting around 38.3. Okay, Ansh, when you're reading, I just 27 to 30 is not a bad score. You have a lot of time to improve, step up your mocks. But one thing I would recommend is when you're reading, try not to think too much. Like I had this problem at a particular stage in my CLAT prep that I used to get involved in the passage and I used to think too much. Like two options, they seem very close. I used to analyze what their implications could be, what a technicality might come up. Don't think, don't overthink. That's why I said whenever you feel like you're thinking too much, spending more than 30, 40 seconds on a particular question, take a step back. Stop there. Don't do more. Go with your gut. Okay. Trust your gut. One very important thing is, especially in GK, all right, this is not a GK session, but you will come across so much content. Like you don't know what's relevant and what's not, right? You just read stuff and then you can't memorize everything. So what you do is rely on your subconscious mind. Your subconscious mind is a lot stronger than you ever think. It stores random facts. And if you have a gut feeling, that's your subconscious mind thinking that's the answer. So when you've gone through a question, you spend 30, 40 seconds and you still don't know the answer. If you feel like you have time, give it a little more time, 10, 15 seconds. But if not, go with your gut. If you feel like you can if skipping it would make more sense, skip it. Skipping is very important. Yeah, so that change your approach to it. When you're reading a passage, don't get too involved. Don't overthink. Overthinking was where I plateaued my score in the legal section, especially. Your attempts seem fine, but one thing I'd recommend is if you're not particularly sure about a question, you're like very dizzy, like you can't choose, leave that question. Leaving questions is a very, very important skill for CLAT. Of course, you can have high attempts. That's giving you more options. You might think if I get a question right, I'm getting one mark positive, but if I get it wrong, only 0.25 negative. The odds make sense that way, but they really don't because these questions rising, you get one question wrong, effectively you're losing 1.25 marks because you could have gotten 1 mark, but you don't get that mark, and additionally you get a negative 0.25. Think of it this way. So skip a few questions if you can. It's very important. Okay, guys, you're asking sources. Okay. The most questions seem to be about sources. Okay, which mock test series? Yeah, I use multiple mock test series. I use my coaching center, the Opus Space mock test series, and I used a couple others here and there, whatever was available. I subscribed to the Career Launcher series. That's all. Yeah, Manvi's question in how much time we have to finish a passage. All right, very very important question, guys. If you think that if there are many YouTube videos that will tell you you have to complete a passage in this much time, right? Time your sections. You can't spend more than 30 minutes on this. Don't. That's, forgive me for not using a more appropriate word. That's absolute stupidity because competitive examinations are very 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 subjective. What I do is very different from what others do, what my friends did to come to MLS, right? Everybody has different things, and do not worry about it. There's no time. Okay, I'll tell you what my thing was when I started a mock. The first 2 to 3 minutes, I skimmed through the entire paper. I got a lay of the land, whatever the entire thing was, and then I used to go to the legal section because the legal section is the most important one, right? And when you're starting a paper, your mind needs to be the most fresh. So I went to the legal. Then I took a 30-second break. I took deep breaths. That's very important, by the way. Calm your brain because that increases your efficiency. I took a breath. I took 6, 7 minutes for GK. Then I went to the quantitative section. I solved it. Again, I took a 30-second break. I went to logic, and then I went to English at the end. Yeah, that's what it was. So, in coming to a difficult passage, like I've been trying to get the message across to you all, do not be worried. All right, you're sitting for a competitive examination. It's not your boards that you have to get 100 on 100. Here, you don't have to look for your absolute best. You have to be the relative best, relative to everybody else giving or taking plant. All right. If a passage is difficult for you and you know you've done your prep, you've worked hard to get to wherever you are, it's not difficult only for you. It will be difficult for the other people too. And all you need to ensure is that you handle that difficulty better than they do. Most people have a tendency to panic when they go to a difficult question, like, oh my God, what will happen? Class is so important. What do I do now? First step, do not panic. I know it's easy to say do not panic. It's harder to implement it. But when you're giving mocks, you will come across infinite questions that are very difficult, that will confuse you, that will trick you. If you think they're too tricky, skip it, but don't sweat it. Because if you let that mental balance be uh, shaken when you're solving it, that won't help. Take a step back and breathe. Like I told you, the breathers I used to take between sections, that's very important. Just close my eyes, take 30 seconds of deep breaths. That will calm your brain down. It's worth giving a shot. Skip the ones you're tricky, come back to it at the end of the passage. 5 questions in a passage, right? Generally. You think the first question is tricky, leave the first question, go to the next 4, solve it, and at the end of that passage, come back to the first question. Right, your legal is going good, 20 out of 25 attempts. Okay, overall attempts are low. Okay, so the primary reason in most cases for overall attempts being low is your reading speed is not up to the mark. So for that, I'd recommend, this is the most general thing I could ever tell you, but read editorials, read books. Personally, I used to read a lot of books, so my reading speed wasn't a problem for me, but editorials will still help. They will improve your vocabulary, which will help English, which will help CR, which will help LR. They improve your reading speed, which helps the entire CLAT paper, right? Read editorials, that's very important. Okay, coming to mocks, how many did you give? I took a little more than 65 mocks. That's that. But don't be worried. I took a lot of mocks. I was prepping for 2 years. Your okay, Ananya, scores are stagnant in 60s and attempts are 75, 85. How can you improve it? And legal is legal. Okay. Attempts 75 to 85, you definitely need to work a little more on attempts. So I would recommend you sit down with a mock you've already done and go through exactly what your mindset was. Like, what did you do first? What could you have done better? Okay, fix a definite thing for you that works. Find what works for you. The section order, like what you do first, English, then logic, then CR, then math, then GK. Whatever works for you, figure that out. You will need to take at least 10 to 15 mocks for that, but do it. That's genuinely worth it. Do that. Try to increase your attempts. Like I said, reading speed. Reading speed is extremely important. Scores are stagnant in 60s. Guys, all of you, I can guarantee this. You can take my word for it. All of you will have a score plateau somewhere or the other, right? I plateaued in the 70s, my first plateau. Then I plateaued in the 90s. That happens. Do not worry about it. Just keep going. CLAT is not about your IQ. You could have an IQ of 150 and still get 15. That doesn't matter much, right? It's about consistency. You have to be very consistent every step of the way. That's why I recommend making a group of friends, right? 2 to 3 people, 4 people, however many you want. Sit together, discuss mocks together, analyze them together. That way you'll get different ideas. You will improve a lot. I had a group of 3 to 4 people, and it was extremely helpful for me. It was for them too. All of us are in NLUs now. Okay. You legal CA, CR, quant. Okay, like the sequence is extremely subjective. You do whatever you think is best, whatever keeps your mind refreshed. So personally, the reason why I did legal, then GK, then quant, then English, then CR, then CR, then English was because legal takes the most brain power, and I love legal. I used to. That's why I started with legal. Take a break, go to GK because GK does not require brains. Just read. If you know it, you know it. If you don't, you don't. Forget it. Then you go to quant. Math personally wasn't a problem for me because I liked it and I'd had a good experience with it, so I went ahead with math. Logic required a little more thinking, So I used to do logic second last, and last was English because it's fairly easy to go through, right? It's fairly easy. That's why I did it. Everybody will have different reasons for choosing a particular sequence. Find your reasons, find the sequence that works for you and stick to it. Don't you follow my sequence just because I'm here right now. Don't. It doesn't matter that way. Latin words, legal maxims, no. You do not need that. Okay, there have only been 1 or 2 years, I think it was 2018 and 19, I'm not sure about the years, where CLAT actually asked the legal maxims. It does not matter. They don't ask you those questions nowadays. But even if they do, when you're giving mocks, you will come across many legal maxims. Some of them will stick in your head, some of them will not. Don't sweat it. Don't try to memorize legal maxims. Some of them, like the general ones, you can, but like ignorantia juris non excusat, ignorantia facti excusat. It's the legal maxim I was talking about. Ignorance of the law cannot be excused, ignorance of fact can. This you come across, and that's how you do it. My total attempts, I attempted 142 questions. Ideal time taken per passage. Okay, so you can't set a particular time for any passage, but I'd say in the ballpark of 5 minutes. Do not exceed 5 minutes in general. You can have 5-10 seconds above and beyond, but that's fine. Uh, Legal maxims, article sections. You don't need to remember articles and sections. That is not important. Never. No single lawyer will remember all articles and sections. Okay, you come to law school to learn how to reason with rules. You don't come to memorize sections. After doing contract law of crimes. Okay, I think that's pretty comprehensive. I haven't done anything more than that either. Anushka Bhagat. So don't worry about it. You've done enough theory. Just keep taking mocks. Doesn't matter if you started prep now, take mocks. Take as many as you can. If, you, if someone wants to read a legal case, yeah, Anish, sorry.
No, no. Do you want to end it? I think that should be enough. The questions would be
I'll just take
endless
a
otherwise.
couple more questions there. A couple more questions that
Right.
were already
Okay.
there. Yeah, yeah. So yeah, if you want to read books, if you have the time to read books in addition to school and everything, if you're a dropper, it's a different case. If you want to, go ahead, but it's not really going to help you that much for CLAT. Of course, it will help your vocabulary, reading speed, all of that. But for the legal section in particular, you don't need to have outside knowledge. That's it. Right, guys, I'll be having different mentorship sessions with NLTI. So do enroll. And yeah, that's it from my side,
Right.
pretty much.
Yeah. Cool, cool. Thank you so much, Akash, for this wonderful session. It was a really enlightening one for me as well as a mentor, and would definitely take insights from you when I next mentor my mentees. Okay, I think you can leave the session. I'll take it forward from here. Thank you so much,
Thank
Akash.
you.
Right. So that was Aakarsh Bafna, All India Rank 6 in 2022, and one of the smartest people in the junior batches. If you have any doubts regarding our program at NLTI, I'd be happy to answer it here. You can check out our Telegram channel via the link given in the description box. Just to give you a heads up what we do at NLTI, we are a mentorship program exclusively run by NLS students who are obviously CLAT toppers. What we'll do is we'll allot you study buddies. Mathili Pathak, the first month trial that we were offering for our early birds has now ended. So now only 24, like no, only the plan available for 2400 for 4 months is available now. What we can do is, if you want, the GK topper notes that are available for sale, alag se, could be included in the mentorship plan if you choose to enroll with us. Right. Any Yes, Ragini, it is cold in Bangalore and it has been raining for quite some time now. Yeah, coming back to NLTI, what we'll be doing at NLTI is we'll be allotting you study buddies, and you obviously know the importance of study buddies. Every mentor that has taken a session with NLTI has spoken that he was preparing with 3 or 4 of his friends, of his study buddies, and how they gave mocks together, they analyzed mocks together and divided GK topics and then collated their notes. And it just helps you out, like it relaxes you, it releases your burden. If you prepare notes for 20 topics, you'll have the notes for 80 topics effectively, because the rest 3 study buddies would make the notes for the next. 60 topics. So that's how NLTI works. Every weekend our mentor will take a session with you for doubt clearing. The mentor will ask you what did you do for the entire past week. You will be accountable to the mentor. He or she will ask you why you didn't do that particular task which they asked you to do, and also help you prepare a roadmap for the next upcoming week. We are also, this is a surprise, this is a secret guy that I am spilling right now. So we are coming up with our own mock test series, and it would be launched within a couple of days. Only the GK section is left, and the rest four sections have been completed. So yeah, you can expect to see our test series by what, 3rd September. And just to assure you that there have been concerns that the quality may not be up to the mark because the mocks are made by students. Just to tell you, we at NLS, we the students at NLS, are the ones who are making mocks for every coaching institution. I personally am making mocks for a few coaching institutions. My batchmates have been making mocks for a few coaching institutions. So we are the ones who are making mocks for every reputed coaching institutions. So there's nothing that if we make our mocks, the quality would not be up to the mark. It's just that we are collectivizing our efforts to provide you quality mentorship coupled with quality mocks at very reasonable prices. Okay, so we are providing mentorship plus test series within the price that a coaching institute not even gives mocks in. So this is just our initiative to help the community that we belong to once during our CLAT preparation. uh, भैया वेबसाइट कब तक लॉन्च होगी? अमन, द वेबसाइट इज कंप्लीट now today. We are just in progress of migrating the existing subscribers, so all those who have enrolled with us will be migrate we have to be migrated to the website. So we are just manually adding you all to the website so that you will be able to access the study material. It's almost ready to, so it will also take like another 2 days to have everything set on the website. How many mocks? For now, we are, because we have our project submissions in NLS and also our exams are in September 20. Exams start on September 25th. We'll be giving you one mock per week for the month of September, and then we'll obviously increase the frequency. So you can expect around 20 mocks till CLAT 2022. Sanch, when will the mock test series be released? I just told you that it will be released within a couple of days by 3rd of September. Right. Uh, any other, what is mentor plan? Actually, I'm new. Samarth, you can refer to our Telegram channel, and you can find all the details about our program there. Anything else? Okay guys, so should I end this session? If you have any doubts, please reach out to us. uh, I'm here for next 30 seconds if you have any doubts regarding the mentorship program. Bhaiya, can we clear exam if we start today? Vaibhav, this is a very subjective question. This is a very subjective question. I need to know your background, how much you are scoring right now, and what do you mean by clear exam? If you mean you want to get into an NLU, then it's obviously very much possible that you can get an NLU. If you want to get into a top 5, if you want to get into NLS, then the answer would be different. We will give on online platform or get PDF. The details have to be sorted out with Bakar. We are not sure if we'll provide you the PDF or it will be available on the website only. What would be the cost of the test series? Aman, the cost would be included. The enrolled students do not have to pay anything extra for the test series. Uh, for other students who want to enroll just for the test series, we are thinking to keep it around 2,000 for 4 months. And this is like not even 1/3 of what other coaching institutes charge. If I'm scoring in 60s, can I get into top NLU, like top 5? Ananya, that again depends on the effort that you are willing to put in and the kind of mentorship or guidance you have. Uh, yeah, so Webhub also, similar answer to Webhub. It's very much possible if you are scoring in 60s right now. When I was preparing, this is like not a secret. I have told this in many interviews that the All India mock that I gave like 3 weeks before CLAT, I just scored 64 and a rank of what, 10K in an All India mock 3 weeks before CLAT. So it is a very subjective paper and depends what is going on in your mind on the D-Day and how well you take your mock scores. So if you are accepting them and if you are willing to work harder, then obviously you can clear. All right, Samarth. our mentors are there. We have five, six, seven mentors now, including Akash. So all these are top rankers. All these are best in their own fields. We have Rishabh, we have Kanishk, we have Anushka, who is great at CR. We are in process of inducting Prem, who is great at maths and scored 13 or 14 out of 15. We have Akarsh, who scored 38 out of 40 in legal section. So we have subject specific mentors also who will be taking such master classes on weekly or monthly basis, probably weekly only. uh, right. Chalo, okay guys, see you then. I hope you liked the session, and please refer NLTI to your friends. NLTI is working like a noble cause, and we are not charging a lot, and so please refer NLTI your friends, because the awareness about NLTI is very less as compared to other mentorship and coaching institutions, and we are doing a similar task as what they are doing, but the awareness is quite less. So I'd appreciate if you uh, tell people about NLTI and ask them to join our Telegram channel or refer to our YouTube videos. Great. Okay, guys. So thank you so much for being patient with me here. And cost is 2,400 for 4 months, and that would effectively boil down to only 600 per month. And that would include mentorship, that would include test series, and that would include all the master classes that we take. All right. Okay, guys. So see you. Bye bye. It was fun to have you around here. You can reach out to me on Telegram if you have any doubts. Cool. Bye bye.